When we look at cases with people involving pre-existing impairments, for instance, I represent a lot of people that are tradespeople. They work very hard. They're in construction, plumbers, tile setters, bricklayers, carpenters, electricians, you name it. They often have some sort of back issues before whatever the accident was. So that would be considered a pre-existing injury or a pre-existing impairment. A lot of people after the age of 30 have developed what's called degenerative disc disease in their back, which is what causes intermittent issues with back pain now and again. The reality is that a person with these pre-existing impairments, even though they had pain, they were still able to work. They were still able to function. They were still able to have a meaningful existence with their friends, family, and loved ones. It's the accident which then causes these pre-existing injuries or impairments to flare up, to become far more serious. Again, the change in function. So the increase, meaning because you're more vulnerable, your increased pain, your increased impairment is actually a helpful thing. In many cases I help people with, it's that change in function that matters. If you were working 5 days a week before the accident, even though you had a pre-existing condition, then you get into a big accident and now you can't work, or you can only work but in a different capacity because of that pre-existing condition, you still have a valid claim. The pre-existing condition is not a bad thing. It's actually something that can help you and justify why what may have been a more insignificant impact or a more insignificant issue for other people that don't have pre-existing injuries. In your case, it can cause significant impairment because you are inherently more vulnerable because of your injuries. And the law talks about how you have to treat the plaintiff as they are. So if you're a thin-skulled plaintiff, this is not something that can be used against you. From the defense side, as I indicated, if your condition would have gradually gotten worse anyways, to the point that you would be at the same place irrespective of the accident, that's the crumbling skull doctrine, that is a valid defense that the insurance industry will always use and will always suggest in any case involving pre-existing impairments. But the bottom line is pre-existing impairments are not the be-all and end-all. This is a misconception that it's the end of your case. That is not the truth. These pre-existing conditions can be helpful. They can also be hurtful. But in my experience, more often than not, they're actually helpful and are actually, from a legal perspective, can be a positive thing in your personal injury claim.